that's about the facts and other things. But right now, the relevant thing is whether they have to show how do they have the locus standi to file this petition. Election Commission is a quasi-judicial body.
Correct.
Two judgments of this honorable.
No, let me just correct you here. Election Commission is not just a quasi-judicial body, it's a constitutional body.
Constitutional
It has,
body.
from my understanding,
Right.
it has two functions.
Right, sir.
One, regulating the affairs of political parties, and which is an ongoing exercise, and the other is the free and fair elections. So probably we are at the moment in the first thing, that regulating the affairs of the political party.
Right.
I would imagine, unless I'm wrong.
I'm trying to submit here is that it is a body which has a power to make quasi-judicial decisions. It's a quasi-judicial body when the matter of dispute between.
Their decisions are orders. They can be
This
absolutely.
Honorable Court has very recently held in 2 cases that such bodies have no locus standi to file the petition and come before the Supreme Court in defense of their own orders. So kindly consider those 2 judgments. In the light of those judgments, they have no locus standi to be here.
देखिए, ये तो फिर भी कॉन्स्टिट्यूशनल बॉडी है. एक सेकेंड, even the collector appeals comes to the High Court, comes to the Supreme Court, when even though it's his own order, he is arguing his own order, effectively speaking. So ये तो constitutional body है. तो just देखिए, then there will be another issue. Then another question of maintainability will arise. If you are questioning their maintainability, then the question of your maintainability will arise. How can you approach a High Court? फिर वो क्वेश्चन आ जाएगा.
Naturally, any adverse order I have right to challenge.
No. Which forum? The High Supreme Court. अभी पहला हमने केस सुना ना, क्या नाम है, APML. वो कानून में लिखा है टू कम टू द सुप्रीम कोर्ट.
डायरेक्ट अपील है वो, डायरेक्ट अपील है.
तो फिर वो क्वेश्चन ऑफ मेंटेनेबिलिटी विल आल्सो कट यू.
No, sir. The thing is, as far as their locus standi is concerned, there are 2 judgments of statutory bodies.
Locus standi, simple सी बात है ना. Locus standi is a different thing from capacity. Their local standi, from what I can understand, is they have passed an order. There's right or wrong is a different thing. We don't go there. And they say if we have to ensure our orders are abided by, unless set aside by a law of a competent forum. So all they are doing is ensuring that even if it's an illegal order, let's not get bogged down in that debate. If they just give up, then the orders will be rendered meaningless.
Then a affected party, which brought the matter before the Election Commission, has the locus standi to file, but not the Election Commission.
Affected party can inform the Election Commission for whatever reason. The Election Commission may act on its own. Election Commission may act on the information of a person, but now that they've passed an order, they're not entitled to defend their own order and surrender.
That's what I'm submitting.
On what basis?
Kindly see the case of a district judge. He passes an order. That order is challenged before the High Court. High Court sets that aside. Can the district judge come before the Supreme Court that in defense of his own order? No, it's a judicial body. Judicial body cannot.
There is a slight difference. Not a slight difference. A major constitutional difference would arise. The district judge falls under the hierarchy of courts to be supervised and controlled by the High Court under Article, I don't know, what is it, Makhdoom?
Whatever it is. I'm just giving an example.
एक सेकंड, नहीं, वो example लगेगा नहीं. Now this is a separate body. You cannot apply that argument. The separate body, I've given you the example of Collector of Customs. Every day they are filing before us. Collector of Customs appeals. His own order is come and it's been turned upside down by the High Court. So he comes before us. We hear him. Nobody's ever raised an objection that they can't be heard.
There are 2 cases recently in which this Honorable Court has held.
बताएं कौन से? Which are those 2 cases?
Yes, those 2 cases. The recent one is 2023.
PLD?
And the other judgment where the ombudsman has...
other judgment, yes.
The other judgment is PLD 2020.
2020. Supreme Court.
Supreme Court 586.
What was the facts of the first case?
They have held.
So first case bataiye, let's go to 516. What is the ratio in that case?
Yes, they held the order which was passed by Commissioner and was challenged subsequently before the High Court, before the Appellate Forum and High Court.
Which commissioner?
That the Commissioner cannot come.
The Commissioner, Election Commission.
Not the Election Commission. In that case, it was Competition Commission.
Gee.
But there is a clear judgment.
Okay. So how is it? No, let's finish with one judgment at a time. How is this judgment applicable to a constitutional body?
Sir, kindly see para 23, page 535. Why I'm putting this before this honorable court?
Please.
The whole exercise may
Let's read
be
it.
unnecessary.
No, let's read it. To be honest, I've not read it, so let's read it.
Yes,
You
sir.
may well be right.
Page 23.
Gee.
It may also be petitioner to mention here that KNN's food which may have been aggrieved of the decision of the tribunal on the point of non-applicability the provisions of section 10(2)(a) of the Act has been impugned the decision of the tribunal by preferring an appeal to this court, and it is the Commission that has challenged the decision of the tribunal on that point by filing the appeal. In this regard, we may observe, though the role of the Commission under the Act is primarily of a regulatory body, it is a quasi-judicial, as well as some provision, as well under the same provisions of the Act. The provisions of clauses A and D of section 10(2) of the Act, in our view, envisages the quasi-judicial role of the Commission while declaring upon the divergent claims and allegations of two competing undertakings. And as held by this court in Wahaki Motasib's case, an adjudicatory body deciding a matter in the exercise of a quasi-judicial powers between two rival parties under a law cannot be treated as an aggrieved person if its decision is set aside or modified by higher court under the law or by a court of competent jurisdiction.
Are you equating a quasi-judicial body with a constitutional body?
Sir, statutory body.
Are you? I don't know what your answer is.
There
First say yes, no, then you
is a
proceed.
distinction between a statutory and a constitutional body. They are all under the law, under the fundamental law.
No, not at all. A constitutional body functions under the Constitution.
Yes.
A statutory body is a sub-constitutional body functioning under a statute. So are you equating the two?
Sir, rules, the certain principles are equally applicable to statutory as well as the constitutional body. If the principle is that a body is vested with quasi-judicial powers, it exercises a quasi-judicial power, passes an order between the parties.
I would call it a constitutional power. The Constitution grants, we don't make this Constitution, we only interpret the Constitution. And I don't want to read words into the Constitution either. The Constitution, in its wisdom, the Constitution makers created a separate constitutional body.
Yes.
Now, you may well be right, and I may agree with you 100%.